Well, hello everyone. Thanks for joining us today. It's 1 o'clock, but I think people may still be joining us, so I might talk slowly for a little while before we get started, but delighted to see you all here.
Yes, hi everybody, welcome. Great to see some names that I recognise in the list of attendees there, so thanks for joining us.
Well, rather than keeping you all waiting, I might get started. Welcome again to the first of our sessions on copyright and fashion. I'd like to start by acknowledging the traditional owners of the land where we are presenting to you from today, and to pay our respects to the elders past, present and emerging. We're going to be recording the session. I hope that everybody's okay with that, and it will be available for viewing later on if you'd like to see it, or if someone's is unable to attend today but did register. So we planned for this seminar to be about 45 minutes long, with some time at the end for questions. So please feel free to submit any questions or comments you might have along the way onto our chat function, and our brilliant Emily Phipps will manage them. Emily is our marketing and communications coordinator, and we'll keep an eye on the chats and we'll come back to them at the end most likely. So today we're going to talk about copyright. So there'll be an introduction to copyright, and then we're going to talk about two main scenarios. First, in those circumstances where you have an artwork that's already in existence, or an artwork that's being commissioned for use on fabric or fashion. Secondly, where you have a fashion collaboration project between the two parties, where they're going to work together on the development of fashion items. I would like to mention, though, at the outset that this seminar is part of the education program within the Best Practice Resources for Indigenous Fashion project. Arts Law is working on this project in partnership with the Darwin Aboriginal Art Fair Foundation, DAF, and IP Australia. As part of the project, in addition to a number of education and consultation sessions taking place online and face-to-face, we're developing resources for people wishing to work with Indigenous fashion and textiles. These resources are for Indigenous artists and for designers and fashion houses wishing to work with them. There'll be a toolkit of best practice resources which will contain a range of things which will be useful at different stages of an Indigenous fashion collaboration, from the first ideas to the final marketing and sales. There'll be pathways, template contracts, checklists, and lots of information and ideas. A website is being developed by DAF to house all these materials as a one-stop place for you to go to when you're contemplating using artwork of an Aboriginal or Torres Strait Islander person on textiles or fashion. Once the website is up and running and the resources have all been deployed, Arts Law and our partners will continue to be available to provide support to people working in the Indigenous fashion and textile sector beyond the conclusion of the setting up phase of the project.
Thanks, Donna. Before I just explain a little bit about what Arts Law does, I thought I'd just introduce myself. So my name's Suzanne Derry, and I'm one of the principal lawyers at the Arts Law Centre, and Donna Robinson is the senior solicitor at the Arts Law Centre. And I'll talk a little bit about what Arts Law does, but I imagine that many of you who are in the room have already got a bit of an idea about who we are. I will just say at the outset as well, to add to Donna's initial comments, that we're aware that this space in which artists and fashion sort of merge and collaborate can be a very complex space. and that every fashion project is going to be different, and that your needs are going to vary throughout a project depending on the scale of what you're doing, and the sorts of products that or garments that you might be looking at developing. We've recently had various conversations with artists and peak bodies within the Indigenous arts space who all tell us that about projects that they're doing, and they differ vastly. So we understand that they are very, very varied things, and we'd encourage you, if you're an Indigenous artist or an Indigenous arts organisation, to seek some legal advice about these projects to make sure that your rights and interests are protected, and to reach out for some best practice advice if you're a label or a designer. So I'll talk a little bit about what arts law does, but I don't want us to spend too much time on that, because I think that the better thing to do if you're wanting an overview of what we can offer and what our services are is probably to head to our website, and just have a look at that, which is www.artslaw.com.au. Most importantly, for artists and arts organisations, for example, arts centres, Arts Law can offer legal advice either free or very low cost. And we're aware that very often these fashion projects don't have huge financial resources behind them, and they may be quite exploratory in nature. You might sort of be trying something new for your arts centre or for your label, or you might be trying a new collaboration. And so you don't have existing capital to pour into those projects. That means that your bottom line in terms of what you can spend on legal resources is probably also quite limited. So to that end, Arts Law can provide support to help you to get there on the legal side of things, at a very low cost basis. We've got, as Donna mentioned, an array of template resources that are really useful for people who are starting to consider some of the issues that they need to think about. And you don't need to be a lawyer to draft an agreement, but it's a really good idea to have a lawyer look over an agreement before everybody finalises and signs it. So coming to Arts Law for advice about any contracts that you might be entering into in this space is a good idea. The resources that Donna mentioned are all incredibly helpful. We've also got a vast array of information about general sort of copyright and contracts and those sorts of things. And Arts Law, as you're probably aware, delivers significant sort of advocacy support for artists and organisations, in particular Indigenous artists and organisations in the legal space. So I will hand back to Donna. Oh, you just unmute yourself, Donna.
That should be right now, I hope.
It is.
So when a designer decides they want to print Indigenous artwork onto a fabric, they may have an image in mind. It may be a concrete image or just a general idea. They may have an artist in mind as well. So if they do have someone in mind, or if they're just thinking about it, they should contact the artist if they have one in mind, or their agent, such as their art centre, and discuss the idea with them. If they don't have an artist in mind, you could still contact art centres to see if they have artists who create work similar to the sort of image that you're starting to think of. So once you've sort of made a connection between the designer and the artist and you're both interested, you can start planning to go ahead. If the designer is commissioning an artwork, they should have a design brief to make it clear what they have in mind. Then you can both start to agree on the terms of the agreement. The contract you want to have in place is a license agreement, otherwise known as a license contract. Because when an artist or a creator gives permission to someone to reproduce their work, we call that a license. So under the license, the artist is giving permission to someone to use their copyright in the artwork in a certain way. To copy the image onto fabric or onto clothing, for example, the license will also need to cover the copying of the image if you want to have it on associated promotional material as well. That all needs to be set out in the contract. So this is separate from the artist's ownership of the physical work. The artist may have already sold the artwork to someone else, but they retain the ownership of the copyright in the artwork. So the permission needs to make it clear what the artwork can be used for. For example, is it going to be a repeating pattern on fabric or on a garment? If it's on fabric, then some of the images may be cut off when the pattern is cut out. Make sure you're okay with this. It's important to make sure that the artist still owns the copyright in their artwork. They will have already licensed it. They may have already licensed it to someone else or even transferred it to someone else who is then the owner of the copyright in the artwork. Or they may have a license of some sort over the artwork to use it for some purposes, but not necessarily the ones that you're planning on using it for. So you need to get permission from the owner of the copyright, and if there's a license holder and they have an exclusive license, you probably need their permission too to use the artwork. You may have seen the news today about the Aboriginal flag and the wonderful release of the flag from the people who had the copyright, who had licenses over the copyright in the artwork. So previously you had to get permission from those license holders before you could use the flag on anything, and they would always charge for that. So now it's been licensed to the federal government and they've granted it free for all to use, which is really marvellous. Another thing to keep in mind in this area is that an artist has moral rights, and Suzanne will talk about a little bit more about this shortly. So that means the artist has the legal right to be credited as the creator of the artwork. You need to ensure that the artist is credited on the garment if wherever is reasonably possible. It is likely to be impractical on lengths of fabric, but the artist can still be attributed on the label if it's a garment, or on a swing tag, or on packaging if it's fabric. The artist also has the right for the work not to be changed in any way so as to damage their reputation. So this could be an alteration or modification to the image, such as just changing the colour or trimming a bit off to make it fit better. Or it could even be using the image in a certain context, such as on swimwear, where using culturally significant images on swimmers could be offensive. Or it could be connected with something the artist is opposed to or doesn't endorse. Any of these kinds of uses could prejudice the artist's reputation, and they have moral rights, legal moral rights in this regard. The third thing to mention just at the outset is Indigenous cultural and intellectual property. So it's important for both parties to think about ICIP and clarify whether there's any ICIP or cultural knowledge in the artwork. ICIP is the right of Aboriginal and Torres Strait Islander people to protect their traditional arts and culture. When working with Indigenous people, it's important to respect their traditional culture and expression. Check with the artist whether there are any permissions needed from elders or custodians, or if there's any cultural or traditional knowledge or content in the image. Does the artwork replicate a totem, which is of great significance to the artist community? Has the artist consulted with the important people, or do they still need to do this? These are some of the things you need to be thinking about in those early conversations between the artist and the designer.
Thanks, Donna. Right, so we're going to talk a bit now about copyright and how that all sort of weaves its way into the sorts of fashion arrangements that we've mentioned. At the outset, I suppose the thing to understand is that the sort of copyright arrangement which might need to exist between a designer and an artist, or a designer and an arts centre, is very much going to depend on what is being done with the artwork. And we're going to go into a little bit more detail in a moment about copyright licensing and thinking about some of the issues. So essentially, any time that you want to use an artwork in any way, other than simply dealing with the physical painting itself, any time that you want to, for example, pop an image of an artwork onto fabric, or you want to put a photograph of that fabric online, anytime that you want to use the artwork in any way, what you're really talking about doing is using the copyright. And that use could fall into different categories under the Copyright Act, but we're not sort of going to worry too much about which of those categories it falls into. Rather, what we're going to do is to talk about how to thoughtfully ensure that you as a designer or artist are covering off on the specific use that you want to make of the copyright in the work, and ensuring that everybody is protected and that the project is a best practice project. So some of the sorts of uses or projects that we see regularly include where an artwork has been specifically commissioned. And often what will happen there is that that commissioning agreement, which requests based on a brief that the artist designs a particular type of artwork for a specific type of apparel or accessories or products, often that agreement will also include the copyright permissions that are required. And so when, as an art centre or an artist's agent, when you're looking at contracts that seemingly commission the creation of an artwork for a fashion project, it's really important that you're also looking at and understanding how the copyright in that project is going to work and what the scope of the use, the extent of the use of that copyright is going to be. Another very common scenario is where you've got an existing artwork which a designer or label or project of some kind has seen and really loves and wants to use. And in that case, they might approach the artist directly or the artist's agent and request permission or a license. So in that scenario, we're not talking about a specific commission, which is going to be a work that's created on a tailored basis for a specific type of product. We're talking about an existing work which may already have a copyright life of its own in terms of permissions that have or haven't been given in respect of that work. And so those sorts of agreements and copyright permissions are really, really often very important to, in that scenario with those sorts of agreements, it's really important to look at the detail around how the work is going to be used. So the next scenario in which copyright sort of comes head to head with the fashion space is where there's a much more fluid, collaborative environment or space in which the artist and perhaps a designer or other artists are working together to come up with suitable designs or fabric concepts or designs. And so those projects perhaps don't have as a starting point a really clear brief, because the idea of the collaboration is to explore how the creative interactions between the various parties land up, you know, where that's going to end up and what sorts of products or garments might come out of that collaboration may in fact really be unknown at the time of starting that collaboration. So if you're in a situation like that and you're working to help an artist and things are very fluid at the beginning, or you are in fact the artist yourself, it's very important to document as much as you can about that project and the creation of the copyright as you go. And next month, we're going to be running a workshop about contracts and fashion, which hopefully will assist in dealing with some of these questions. The other items on that bullet point list that copyright sort of relates to include the creation of textiles, which could really be one of any of those first three things, the creation of specific lines of apparel and matching accessories or accessories independently, and then the creation of products by art centres, which really is something that we're aware is a very growing space. So art centres are now quite commonly working with their artists to develop perhaps fabric or garments. And they may be doing that so that the point of sale is something they control. In other words, that the art centre itself controls the distribution and sale of the work or the garment. But the art centre may also be working with an external party, label, designer, fashion house, and may not have control over the distribution of the work. And I know that that's something that art centres are really very interested in from a copyright perspective, because there are some questions around control of the intellectual property once we start talking about external distributors or external parties, once the art centre is no longer the point of sale. So a brief overview of copyright is that it's sort of embodied in a piece of law called the Copyright Act. That law dictates that on the creation of an artwork, copyright will automatically vest in that work. And that protection is something that's free and you don't have to register to get it. The Copyright Act also gives creators moral rights. And sometimes we get the impression at arts law that there's a bit of a myth that people believe that crediting artists is just something that people offer to do, believing that they're somehow perhaps doing the artist a favour. It's not the case. Artists are legally entitled to a credit under the Copyright Act, and they're also legally entitled not to have things done with their work which would constitute a derogatory treatment of that work or infringe on the integrity of that artwork. So this is where it's really important, if you are a designer or a label, you're using somebody's copyright, to consider how you will do that in a way which does not infringe on their moral rights. In other words, how will you create garments or fabric which don't interfere with the integrity of the authorship of that work? And that is a really important thing to have an open conversation with the artist about and their agent about, because, you know, as Donna said, if you're needing to cut, a garment out and the garment is on fabric, which is a reproduction of an artwork, you are going to have to be cutting out a portion of that artwork, essentially. So having a discussion with the artist about how to do that in a way in which they are comfortable that their artwork is going to be represented with integrity and honour, I think is a very important thing to do. And what a lot of people do to deal with that issue is to have really sound clauses in their contracts around proofs and approvals. The other thing to know is that even if you plan to use artwork for a non-commercial purpose, you will still need to get the copyright permission from the artist to use the work. So this is a bit of a bullet point list of things to know about copyright licensing. But as I said, it really depends on what the project is. When we're talking about, what should I be aware of? Essentially, a license is a type of contract, and we have templates of those contracts that could help you on your way if this is something that you're new to. The other thing to know is that the Copyright Agency is a collecting society. They are not the Arts Law Centre, they are separate to our organisation, but they are the Federal Collecting Society for the Visual Arts and for writers. And so what they do is they can negotiate a copyright license on your behalf if that's something that you want them to do. Emily can provide a link to their website in the chat if that's something that anybody would like to find out more about. It's very important that if you are looking at entering into a copyright arrangement with anyone, whether it's on behalf of an artist or as an artist directly negotiating your own deals, that you make sure that you get those arrangements in writing. At Arts Law, we very often receive phone calls or email requests for legal advice where the problem essentially stems from a lack of clarity around what the arrangement is, because nobody has ever put that arrangement into writing. You need to be aware also that as an artist, you have a right to negotiate contracts. Even if you're given an agreement which is in writing, don't assume that that's a license you simply have to sign as is, take it or leave it. We've assisted Indigenous artists who are licensing the use of their work for fabric and for garments, and we've negotiated better arrangements for them each and every time that we've assisted them. And I'm quite certain that the Copyright Agency would say the same thing. So it's very important to get that advice on the license and also be comfortable with negotiating if that's what needs to happen, and arts law can help with that. So Donna, I'll hand over to you to go through a bit of a list of the sorts of things that are included in a copyright license.
Sure, thank you. Well, as Suzanne just said, every copyright license has the potential to have something that's unique to your circumstances, and you should always suggest changes to the contract if someone gives it to you, otherwise called negotiating the terms of the contract. Or if you're using one of our templates, feel free to adapt that template contract to suit your circumstances. However, regardless of what's unique to your circumstances, you will need to make sure that the contract sets out various key things. And I'm going to go through some of the key clauses to look out for in a license contract, and hopefully answer a couple of the questions that came up in the chat about that as well. So firstly, you need to identify the parties to make it clear that you've got the copyright owner and the person who is intending to use the artwork, who's seeking the license, permission to use the artwork. We often call the artist the licensor in this contracts, and the other party is the licensee. So the licensor gives the licensee the permission to use the artwork for the purposes set out in the contract. As well as that, the license should also identify which artwork is being used. It can be more than one piece of artwork, it can be multiple artworks, but it's very important to have images of those artworks if possible, and you attach them to the contract. The reason I say that is because sometimes artists create images that may have, they have a certain style or a certain image that they really like to work with and to repeat. So you've got to make it clear that you're giving someone permission to use this image, not another image that may have a similar motif on it or a similar subject matter. So those kind of little things can actually be quite important. But one thing about a contract is if everything goes really well, you don't need to refer to them. Part of the purpose of a contract really is to be there as a checklist when things go wrong. So every contract will have have a clause about what to do if there's a dispute, and it will set out a sort of a step-by-step process of what you need to do. And we'll talk about that a bit more in the next session as well. So then the contract also needs to describe what license type is being given permission for. So it can be an exclusive license, which means that no one else can use that image for the duration of the contract. Or it can be non-exclusive, which means that the artist can continue to license the artwork to other people. So that, and thirdly, it could be a sole license, which means that the artists continue to use the artwork themselves, but they can't license it to anyone else. So I'd say non-exclusive licenses are probably the most common, but designers need to think about whether they'll be happy for someone else to be given permission to use the image. And obviously, if an exclusive license is being sought, the artist doesn't have to grant it, by the way, that's open for negotiation. But if it is an exclusive license, then it's going to cost a lot more than a non-exclusive license. Because non-exclusive means you can license the artwork to other people, you can continue to commercialize your artwork. The third thing to think about is what is the scope or purpose of the license. So it's not willy-nilly, you give someone permission and off they go, they do whatever they like with it. It's very much, and that's why it's important to have it from writing, it's very much limited to what the permission is given for. For example, it might be for a series of t-shirts or on a football jersey or for the summer collection of a fashion house or on specified items of clothing. So, you know, spend a bit of time talking between the two of you, the two parties, about what the license is for, what permission is being given, and then set all of that out clearly in the contract so that everybody understands what it is you're agreeing to. You can include in a contract if you want to limit the use of the artwork. You know, for example, if you don't want it on swimwear or something like that. And there also can be limits, and should be limits, in the contract on how many products can the designer create. The purpose of that being so that if there's an agreement for 50 or 500 items, but then the product's selling really well, then the designer can come back and negotiate a new deal with the artist. They also, as I said earlier, think about what additional promotional uses would be allowed. And as well as that, think about whether the licensee, the designer, can grant a sub-license or assign their rights to someone else without getting the artist's permission first. We would recommend that they do have to approach the artist first, because they might be selling it on to a big conglomerate, whereas the artist was interested in the contract in the first place because it was with a sort of someone in a sort of an artisanal kind of product range. Any contract should also indicate the term of the license. How long is it going to be for? Is it going to be for 1 season? Is it going to be 2 years? It's going to be 3 years? Again, you can always come back and negotiate an extension if everything's going well. Better to have it tied up and then renegotiate than have it go for a long time. You might even want to have it as a term that if they don't use the image for a particular, you know, after a year or two, then then the license is ended, is another way of dealing with that, so that the artwork isn't just frozen in a netherworld and nothing comes of it. The contract would go into great detail about payment, how you're going to be paid, what you're going to be paid, when you're going to be paid, and we'll talk in more detail about different methods of payment in the next seminar. But payment is commonly a mixture, or is either royalties or an upfront fee or a mixture of the two. And that's something for negotiation between the parties. A contract will always set out what the rights and responsibilities of both parties are. We sometimes call them warranties set out in the contract. That can be things like the quality of the fabric and clothing to be created, delivery dates. You might want to specify which retail outlets can be used or which can't be used. Moral rights need to be set out in the contract, and it's important not to waive those rights or consent to not being credited, because, you know, a lot of this is about the reputation of the artist getting out there with the products as well. Samples and mock-ups should be included in the contract to be given to the artist for approval before going ahead with manufacturing in the first instance, and then with distribution after the products have been manufactured. And if there are to be any changes to the image in any way, you know, whether it be colours or anything like that, it should be in writing, and have a think about whether there are any approvals like that also need to be required under the contract. The contract should have something about ICIP. Make sure you know whether there is any or isn't any in the artwork, and if there is any and the custodians have agreed to the use of the image, then it's wise to have a notice of custodial interest that is always associated with the artwork. Termination is another thing to mention in contracts, how to end the contract. Most commonly they expire at the end of the term, but there can be other ways that they could end, such as, you know, if the design house or the designer goes broke or something like that. Promotion, which I mentioned earlier, it's important, you know, the authenticity of the work is important when we're dealing with Indigenous artworks, and often the designer will want to use the artist's name and biography, and the artist may be asked to contribute a photo or a background story. Put all of this in the contract so it's clear about who's doing what and what the artist is doing in exchange for the payment that's been agreed. So that's all I really wanted to say about that for now. Suzanne, if you want to go on.
Yes, thanks, Donna. A couple of questions have come through around royalties, and I'm happy to touch on that more in the question time, but I thought, given we've just spoken through a list of the sorts of issues to be aware of, and that one of them was payment, it would be worth just explaining that, of course, just like every license can differ, the way in which the artist is paid differs from license to license. So it may be that the artist receives an upfront lump sum for the permission that they're granting, or it may be that they're given an upfront sum and a percentage as the work sells or the garments sell, or it might be that they receive their payment only through royalties, and just to explain royalties, it's essentially a share of or a percentage of either the wholesale or retail price of the garment. So as Donna said, making sure that those sorts of clauses in a copyright license are really clear and articulate exactly how somebody is going to be paid is incredibly important, because we have seen artists who enter into agreements which seem on their face to have quite decent payment clauses, but when you sort of break the surface of the payment clause and really understand how it operates, it could mean that the artist is not receiving payment until all of the recoupables on the fashion houses side are met. It might mean that the artist is only receiving payment of a wholesale price, which they have no visibility over or control over. So there are lots of reasons that I think that particular clause deserves additional scrutiny and critical thinking when you're looking at a copyright license. Someone else asked a question about whether or not these complex issues in copyright licenses are something that arts law can give advice about. And they absolutely are. If you're an arts centre or an artist and you'd like some advice about how to deal with some of these issues, we can absolutely look at these agreements and provide legal advice for you. So just briefly, because I'm aware of time, copyright in collaborations in which there is a fashion project that perhaps is a bit more fluid, as I mentioned, can lead to all sorts of questions. And if you don't have clear discussions at the outset about the scope of the collaboration and the ownership of any outcomes of that collaboration, for example, any copyright works that could come out of the collaboration, you can really get yourself into hot water, and it can become very problematic for the future of that collaboration or the future of any garments or products that you might develop. So some things to think about in a creative collaboration for fashion projects is firstly understanding that the law is going to call you joint authors of a work or joint owners of a copyright work if more than one person collaborates to create a copyright work. And so if that's not your intention, you don't want that joint authorship or joint ownership to be the way that the work is held, that's something that needs to be dealt with in writing at the start of the project. Being clear and articulating to an Indigenous artist who you're working with on a collaboration what the scope and intended outcomes, or in fact having an agreement or an open discussion about what their goals and objectives are for the project and what they would like to achieve, so that there is equality in that discussion and everybody agrees on what it is that they want from the project, I think is very important. Unfortunately, arts law has seen a couple of scenarios where people go in with very clear ideas about what they would like out of the artist, and that perhaps is not necessarily articulated so clearly in conversations with the artist, who can, then really not have a say in that conversation, and that generally leads to pretty poor relationships that aren't repeated through projects like that. So it's important to have those open and fair discussions at the start of any collaboration. Don has discussed ICIP quite a bit in terms of cultural approvals, but where we're talking about collaborations, it may be the case that as part of that collaboration, an Indigenous artist or community is providing access to information which may or may not be sacred or secret, or particular cultural rules might apply to the way that that information might be used. So it's important to be asking the artist and the community about the information that you've been given if you're a designer or a fashion house, and checking whether or not it's okay to use that information. And I think coming back and revisiting conversations is a very good thing to do. Again, the scope of these sorts of projects can shift and change over time, and that's not a bad thing as long as everybody is along for the ride. But, if you have one conversation at the outset and then only revisited, at the very end, things may have changed substantially. All right, so what do you do if you discover as an artist or an agent for an artist, like an art centre, that work has been used without an artist's permission?
Yes, so as many of us probably know, the increasing use of the internet to promote and market artwork has led to an increase in copying online images without permission. So when we use the word infringement in this context, we mean breach, either of law or of someone's rights. The words infringement and breach are used interchangeably in this context. So we have had many artists contact Arts Law where they've found their images being sold on clothing on the internet and they hadn't given permission to use the artwork. Websites can even insert the artwork onto a realistic item of clothing, like a hoodie or a dress, without actually creating the garment, though it looks like one. Some are so dodgy that product isn't actually for sale, it's just a scam to take your money. In all of these cases, this is a breach of copyright and also of moral rights if the artist isn't credited. It can also be a breach of consumer laws, and Arts Law can help advise on these kinds of legal issues. So it can be more problematic when the person infringing the artist's copyright is based overseas, as different laws can apply in different countries, and some countries' laws may be more lax than Australia. So I suggest that if you do promote your artwork or products on the internet, you should check regularly to see if the work has been copied. There are tools like the Google image search tool which can help with this. Some tips to try and minimise the risk of others copying online images are things like having a watermark on the image, or position yourself in front of the image of the artwork, use low-res images, disable right-click so people can't copy the image, or use the copyright symbol to remind people, because sometimes it's ignorance rather than malice that causes people to copy artworks. So what do you do if you find your work has been copied and your copyright infringed? If you find an item on the internet that appears to be a copy of your work, you need to decide if it is a copy or just a remarkable similarity. They don't need to copy the whole of your work. The test is whether they've copied a substantial part of the original work. And that test is about the quality of what's been copied, not the quantity. Is it a distinctive or essential or recognisable element of the original artwork? You'll need to make sure you have evidence to make sure you can prove that you own the copyright, that you're the creator of the original work. And whether you're a fashion designer or an artist, you should be keeping those sorts of records, somewhere on your computer, in case the need ever arises, because someone may accuse you as well. So you need to have those records, not just for in the event of you finding your work's been copied, but in the event of being contacted by someone else. So keep good records of when you draft a design or draw or paint an artwork. Then the first step to take if you do come across some illegal copying is to write to the host of the website and state you own the copyright and ask them to remove it. Now, if that fails, then the next steps are to issue a takedown notice, which is when you communicate with the ISP who's hosting the website, and they will take the notice down if they're notified that it's a breach of copyright. If that doesn't work, then you've got mediation or the potential to bring a court claim. And at each step, I'm only going to these things very briefly, but at each step of this way, Arts Law can help you by giving you advice about what to do and to help you with the letters that you need to write or the takedown notice you need to create.
Thanks, Donna. Yes.
So, Suzanne, I know we've got a couple more slides there. Do we want to briefly refer to those or move on to the...
Yeah, I think we could probably take some questions now. Just conscious of time and that people may need to go. Does anyone have any questions? I've seen a few things coming through the chat, so maybe I'll just sort of start skimming through those, or perhaps Emily, you could help us with any questions that you have seen come through.
Sure.
And while we're getting those together, I'll just mention that we're just finalising an information sheet on fashion and textiles at the moment. So we'll be able to circulate it to all the registrants in a link sometime in the next week or two, and certainly before the next session on the 24th of February.
Great. Thanks, Donna. Yeah, there's been a few questions come through. So somebody has sort of asked, can you give copyright to several different companies, which I think, Donna, you touched on a little bit, but can you sort of explain a little bit more about exclusive and non-exclusive licenses?
Okay, well, an exclusive license means that if your artwork is, if you give an exclusive license to someone to use your artwork, that means no one else can use the artwork, even the artist. If it's a non-exclusive license, the artist can continue to use the artwork to, create similar artworks or to license it to other people.
So I might just add to that, Donna. If you're an artist who's already given a company permission to use your work, and you're trying to understand whether or not you can give other companies or businesses permission to use your work, a very important starting point, without providing advice on this, is to have a clear understanding of what the contract with the first person you gave permission to says, because that contract may or may not dictate your ability to grant subsequent permissions to other people. And sometimes those agreements can be very detailed. So making sure that you understand each set of permissions that's been given along the way is very important. And this is also why, as Donna mentioned, getting advice about a copyright license before you sign it is a very important thing, because unfortunately I've seen agreements where artists are asked to assign or give away their copyright to the designer or to the label, when that is not at all necessary in order that the fabric or garment can be produced. And so just understanding some of the sort of commercial realities weighed up with the legal issues is something that you might need a bit of help with. Emily, were there others?
Yeah, there's a couple more. Somebody has just asked, what happens if you have a license agreement in place with an artist and the artist passes away?
Well, if the artist passes away, then their copyright is a part of their estate. So it's not just the money in the bank or the artworks themselves. The artist also passes their copyright on to their next of kin, either through their will, or if they don't have a will, it goes through the laws of intestacy. So basically, if you want to use the artwork of an artist, then if you know who their art centre was, I would contact the art centre, because they would be able to refer you to family most likely. And if not, it becomes a bit more difficult to work out who the family is. So you've got to do a bit of PI investigation, work out who the family is.
Sure, great. And we've just had one more question come through. Someone's asked, if if I bought a fabric that had a sort of an Aboriginal print or sort of some kind of Indigenous artist's work on it from just a fabric store, would I need to go and get permission from the artist if I was going to make that into sort of products or designs?
It's a great question. And it's probably fraught with a whole lot of different legal issues. So lawyers love those sorts of questions. Donna, I don't know if you want to make a couple of comments about that scenario.
I was simply going to use my usual brevity and say that if you buy material, there's an implied license that you can, and it's material from a fabric store, there's an implied license, if you like. That's the word that the lawyers use, but in other words, you have permission to use it to create products. And I think that that would include commercial products.
Yeah, some of the complexity there includes a question around what sorts of consents the manufacturer of the fabric may have got at the time that they got the permissions, and other questions around whether or not commercially, from a consumer law perspective, creating products which embody Indigenous designs and perhaps suggest that the work is an Indigenous work could become issues. But it will very much depend on what you're wanting to do, and the scope of any consents that were originally given in relation to the fabric. So yeah, can be complex. I think. Sorry, you go ahead, Donna.
I was simply going to say, I noticed a question from Anna about how long copyright lasts for after death. So copyright lasts for 70 years from the death of the artist. So that could be multi-generational, in answer to your question, Anna, and in which case it would pass potentially to the children and then to the grandchildren of the artist. But after 70 years, any artwork, or any written work, any original work is in the public domain and everybody has access to it. But if you're copying an image from a book that was published 10 years ago, then the 70 years can start to run much later than merely the death of the artist. But if you go back and find the original work, then you've got 70 years from the death of the artist.
Is there anything else there, Emily, that you'd like us to pick up on? Or?
I think that's everything, unless there's anyone has any sort of last minute questions they want to pop in the chat or remind me of something I've forgotten. I think you've covered everything.
That's great. Well, thank you very much for your participation today. It's been delightful, and thanks for everybody sort of jumping into the chat and keeping us on our toes there as well. That's great. Emily will circulate some information to the participants, which will include some links to useful templates and other documents. Have a really wonderful day. Thank you so much, Donna.
Thank you. And thank you for everybody.